she was in their care. That they did everything they could to conceal the harm that was done to her. I've been talking to you for less than 60 seconds. They waited 3 minutes and 50 seconds to say she wasn't breathing. And so what do we have to talk about? What are they charged with? They're charged with aggravated murder, felonious assault, committing child abuse, recounting endangering children, and tampering with evidence. So let's talk in detail about each and every one of these offenses. We believe we've shown you enough evidence to establish that both defendants are guilty of aggravated murder. That they did purposely cause the death of Aniya Day, who was 4 years old. And we know that a person acts purposely when it's a person's specific intention to cause a different result. And so what evidence do you have? You have the testimony and you have the physical evidence. And so what evidence do we have to support the act was purposeful? Dr. Philo testified to you that there was blunt force trauma to Aniya. Someone hit her. And that blunt force trauma caused her to have a stroke. And she didn't die right away from the stroke. She lingered. She suffered. No call to 911. Dr. Philo testified to you that it could have been anywhere from 2 weeks to 3 months. That's a purposeful act. And how do we know the length of time before that 911 call is made? Because we have a call. You know they didn't call a report until March 3rd. That's purposeful. And so what else do we have? What other evidence supports the defendant's purpose to cause harm and kill Aniya? Severely malnourished, 26 pounds at the time of her death. That's the same weight she was when she was 18 months old. You have multiple witnesses testify to you the extent to which Aniya was emaciated. You have one officer talk about being able to see the knuckles in her finger. You had other paramedics and officers talk about being able to count the ribs on her body. A prolonged period of time that she was allowed to lay in that bed, unable to walk, suffer, and die a slow death. That is how you determine that their purpose was to kill her. And then you have the details about the severity of harms to Aniya. Her pancreas was digesting itself due to lack of food. There were ulcers in her stomach due to lack of food. And during the slow, painful death, this 2 weeks to 3 months, not once did they seek medical attention for Aniya. Not once. That is how you get to purpose. That they caused her death? Well, the evidence is clear. They were the only ones that had care, custody, and control of Aniya. Deonte Lewis and Sierra Day. And we know that she was 4 years old. And if that's not enough, there's more evidence of her purpose because you see there was a pattern of behavior that shows us their purpose. We know as early as 2017, there are reports of harm to Aniya. And we begin to see from that pattern of behavior that when someone steps in and says, hey, Aniya is being hurt, what do the defendants do? Well, they remove Aniya from those circumstances. They remove her from those situations. And so Harbor Crest finally gets fed up. They call the police. They take Aniya to the hospital on May 18th of 2017. And then lo and behold, Aniya is pulled out of Harbor Crest daycare. That speaks to the intention, the purpose to cause harm to Aniya. And then we turn to September 2017. Aniya's last time that she visits with her father, Michael Garrett. and he sees the injuries to his daughter. And he photographs Aniya's injuries, and he calls the police and says, someone is harming my baby. I need help. He did the right thing. And what does Sierra do? And at this time, Deonte's in the picture as well. That's the last time that man got to see his daughter. Sierra gets a protection order to prevent him from seeing the harm they continue to cause to Aniya. That's how you know the purpose is to kill her. And then we still have more. Erika Johnson, Sierra's home sister, says there's something wrong with my niece. She is being harmed. Help her. And what happens? Erika's taken out the picture. She is no longer allowed to see Aniya. She no longer has interactions with Aniya. That is how we know purpose. That is how we know was their intention to kill her. And then we move forward to December of 2017. And Children and Family Services is involved again. And you heard the testimony of the social worker, Laura Green, and everything she did to try to find collaterals, as she described them, to substantiate what was being done. And how every point in time, Sierra sought to conceal it. Conceal it so much that never disclosed that Deonte was in the picture. But we know from the evidence submitted to you that he was. He had been in Aniya's life since July of 2017. Both of them acted to conceal the harm that was done to Aniya. And even still, you have the workers from Get Ready, Set, Grow who begin to observe things and say at one point in time, the last time one of them see Aniya, she's being carried out by her mother because she's sick. That's January of 2018. That was the last time anyone saw Sierra, Aniya walking. And so what more do we have to show you that the purpose, their intention, was not only to harm Aniya, but to let her die a slow, painful death from the harm they inflicted on her? You have all their interactions. We know on February 1st, 2018, both Deonte Lewis and Sierra Day are moving into Harbor Crest Apartments. We know on February 9th, the officers are interacting with Sierra Day and Deonte Lewis at Harbor Crest Apartments. Not once did they say, hey, we have a sick child in our apartment. Can you help us? Neither of them. They continue to let her suffer. They continue to let her deal with the effects of that stroke. They continue to let her die in her bed. We have February 11, 2018, 4 o'clock in the morning. Aniya's not with them. She's still at home, dying in her bed at Harbor Crest, at Cultural Gardens. Their defendant, Deonte Lewis and Sierra Day, are getting rights from police officers after making up some story because it's cold outside. While Aniya, suffering the effects of that stroke still, in that bed at Cultural Gardens. February 21st, we know defendant Lewis is still around because Sierra Day makes a call to the police saying, hey, I need to report a theft. In that police interaction, there's no mention of, I have a sick child in my home, please help her. But we could make a report about a laptop and a tablet, but not about Aniya suffering from her stroke. We know from Isaiah that sometime in February of 2018, he goes to his twin sister's apartments at Cultural Garden. And the defendant, Deonte Lewis, is there. And they're hanging out and drinking. And Isaiah goes in to check on his niece because he had been told previously by Sierra, Aniya's not walking. You heard Isaiah's testimony. You heard how he described Aniya. She slowly lifted her head and said, Uncle Isaiah, Uncle Isaiah. See, at that point in time, Sierra had disclosed that Aniya wasn't walking. There were issues with her eating. The defendant, Deonte Lewis, was sitting there on the couch while Sierra and Isaiah were having this conversation about Aniya. This is how we know their purpose. This is how we know their intent, the way they acted every step of the way after that initial trauma to Aniya. They did nothing. Everything was about them. Nothing was about getting help for her. Nothing was about taking ownership to the harm they caused to Aniya. And we know that somewhere, we know on March 8th, the officers respond to Harbor Crest Apartments. Again, both defendants are present. Again, none of them mention anything about Aniya, still allowing her to linger in that bed, slowly deteriorating, slowly dying. We know sometime in March, there's another call from Department of Children and Family Services reaching out saying, we need to come do a home visit. There's a custody dispute. We know Mr. Garrett immediately responded and met with the social worker. And what do we know about Sierra? She set an appointment for March 12th. Never once telling that social worker, by the way, I'm no longer at Harbor Crest. I moved to Cultural Gardens in February. There was no intention of ever letting anyone see Aniya. They knew then that Aniya was dying. Still, didn't ask that social worker, I have a sick child. Give me services, give me help. Let me do something to save her life. Every step of the way, they continue to fail Aniya. We know on March 10th, both defendant Lewis and defendant Day are still together. We see them at Chipotle, getting dinner with a bag full of shopping bags as they prepare to go back to Cultural Garden Apartments. And then we know finally, on March 11th, 2018, they make that call to 911, where they wait 3 minutes and 50 seconds before ever saying Aniya wasn't breathing. Did cause the death of Aniya Day as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault, committing child abuse, endangering children. And so what evidence do we have to support count 2? Well, I have all the evidence from count 1. But we also know that the stroke which caused Aniya's death resulted from blunt force trauma, right? We know the black eye occurred sometime prior to her death, and we know Aniya was unable to walk as early as February of 2018. And so when we talk about what is a proximate result, well, of the offender committing or attempting to commit an offense of violence. And so we move to count 4, which is the permitting child abuse. And what evidence do we have to show that these defendants allowed child abuse of Aniya? You have the same signs of injury to Aniya. Because remember, there are multiple visible injuries seen to Aniya over a significant course of time. That was testified to. That's documented. We know her weight. We know she was severely malnourished. And you can see from the medical examiner's photos the ulcers in her stomach. That's how you know this death was so slow and painful. It was allowed to occur over an extended period of time. Not once did either of them speak up and say, please help this child. Not until it was far too late. Felonious assault can knowingly cause serious physical harm to Aniya Day. And we turn to the knowingly portion. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. And so how do we know the thought process of the defendants? It goes back to the stroke and the testimony you received from Dr. Philo about the left side of her brain and how the frontal lobe, due to the blood clot and the pressure building from that blood clot, caused the stroke. And she still lay there, slowly dying, even after that. That's how you establish knowingly. That's how you establish physical harm. That's how you establish the cause. And so we talk more about the permitting child abuse. Being a parent, guardian, custodian, or person having custody of a child under 18 recklessly caused the death of Aniya Day as a proximate result of permitting the child to be abused, to be tortured, to be administered corporal punishment, or other physical disciplinary measure, or to be physically restrained in a cruel manner or for a prolonged period. We only have to establish one of these. That's the reason the ors are there. It's not all of these being required, it's one or the other. And recklessly, a person acts recklessly when with heedless indifference to the consequences. He pervasively disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or likely to be of a certain nature. So, what evidence do we have of permitting child abuse? Well, there's no question that Aniya was the biological daughter of Sierra Day. And so it turns to Deonte Lewis. And how do we know that Deonte Lewis is responsible for permitting child abuse? What evidence do we have? You'll have the 911 call with you. Go back and listen to it. At the beginning of that call, Deonte Lewis tells us that he is acting as a parent or guardian of that child. He tells us on that 911 call, I am her father. Don't take my word for it, take his. You'll hear it in the call. You heard it in the call. You heard testimony from the officer, the responding officer, that when they arrived on the scene on March 11th of 2018, Deonte Lewis identified himself as Aniya's stepfather. He is putting himself out, representing himself to be her father. That is someone who is in care, custody, and control of a child. And not just that, we have all the dates where he was present and interacting with Sierra. All those dates when Aniya was there. After the stroke occurred, slowly rotting away in that bed, being starved to death, malnourished, emaciated. February 1st, 2018, you have verification that Deonte Lewis was present. February 9th, 2018, we have evidence Deonte Lewis was present. February 11th, 2018, we have evidence that Deonte Lewis was present. February in 2018, the date that Isaiah couldn't remember, you have another verification that Deonte Lewis was present. March 8th, 2018, you have evidence that Deonte Lewis was present. March 10th, 2018, you have evidence that Deonte Lewis was present. And March 11th, the day they finally called 911, you have evidence that Deonte Lewis was present. He was present in Aniya's life. He presented himself as her father on 2 separate occasions. He allowed her to suffer and was present for her suffering. He is responsible just as much as her mother for committing the abuse that occurred to Aniya. And again, we know Aniya's age is 4 years old. And so what else do we have? Well, we deal with the approximate result. What evidence do we have to know the abuse that occurred to Aniya? We talked about all these things before. We know the injuries and harm that was caused to Aniya. That hasn't changed. That remains. And then we add one more thing from Dr. Philo's testimony. Because as he took that witness stand, he testified that anyone who had a baseline of exposure to the child would have known that medical treatment was needed. Those were his words. There were several questions posed to him. Well, what if they weren't around the child every day? Anyone with a baseline of knowledge of the child would have known that medical treatment was needed. Deonte Lewis knew Aniya needed medical treatment. He was present. He saw her. He presented himself as her father, and he did nothing. He is just as responsible as her mother. Count 5, endangering children, did recklessly abuse Aniya, and the violation resulted in serious physical harm. We previously discussed the requirements for recklessly, talked about the evidence of harm caused to Aniya. That does not change. Talked about recklessly. That does not change. But one of the things about recklessly I want to remind you of, a person acts recklessly when with heedless indifference to the consequences. He pervasively disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or likely to be of a certain nature. How do we know that they pervasively ignored the risk, the fact that Aniya lay in that apartment, in that bed, after that stroke dying? We know what they were out doing. We know that from the calls to the police. We know from the 4 a.m. ride from the bus stop back to the apartment. We know from the day before, finally calling 911, them having the audacity to go get them some takeout as Aniya lay in the bed dying. Count 6, endangering children, did recklessly torture or cruelly abuse Aniya, and the violation resulted in serious physical harm. Again, we have the recklessly standard. Again, all the same testimony. And don't forget Dr. Philo's testimony about the time frame, right? 2 weeks up to 3 months. It's a time period of suffering we are describing. Anywhere from 2 weeks to 3 months. From the time that Aniya is first struck to cause a blunt force trauma, for the blood clot to form in her brain, for the blood clot to push down on her brain to the point of causing at least 2 separate strokes. That's the evidence you have that there was cruel abuse of Aniya. She suffered in a way no child should have to. And Dr. Philo also testified that he had not seen a stroke like this in a child the age of 9. That this was one of his first, and he testified to the number of autopsies he's performed, well over 3,000. This is the first time he's seen a stroke of this nature in a child of 9's age. So again, what evidence do we have of recklessly? You have all the interactions that are documented in February and March. Not once during those interactions with law enforcement, mind you, did either Deonte Lewis or Sierra Day say, we have a child dying in our home who needs help. They knew how to get to the hospital. They knew how to call 911. On one occasion, they were picked up from the emergency room of the hospital to take back to the apartment. They could have said something then, and they chose not to. Count 7, endangering children. A parent, custodian, or person in local parentis, meaning a person acting as a parent or person having custody or control, to recklessly create substantial risks to health or safety of Aniya Day by violating duty of care, protection, and support, and the violation resulted in serious physical harm. All the same information we already have. The defendant presented himself as father on 2 separate occasions. You have listed every interaction throughout February and March that is documented, that you heard testimony about, where both defendant Lewis and defendant Day were present. And again, Dr. Philo's testimony about the range of time than Aniya lay in that bed suffering. Count 8, tampering with evidence, that knowing that official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. Cleaning supplies. You heard several witnesses testify to how clean the home was, that the home smelled of cleaning supplies. That was the odor that they smelled when they walked in. And you have the testimony of the paramedics who first walked into the apartment and what their observations were. In March of 2018, the air conditioner was on, and the apartment were both defendant Lewis and defendant Day were present. And as the EMS workers walked into the apartment, they see Aniya laying directly under the air conditioner that was turned on. I heard them testify that her body was cold, rigid to the touch. How do you know there was tampering with evidence? What proof do you have? You have the way Aniya's body was found. You have the cleaning supplies still lined up on the counter. Did knowing the official investigation or proceeding investigation, any record, document, or thing with purpose to impair its value or availability, right? So the purpose of cleaning the apartment was to impair the availability of evidence. The purpose of placing Aniya's body under the air conditioner was to prevent the odor of her body from leaving that apartment. And so we have to talk about the various levels of mental states associated with each count. And I tried to discuss them as we've gone through, but I want to talk about them again because it's so important that you understand what has to be established. Again, how do we determine their purpose? The multiple reports, the constant isolation of Aniya as soon as someone started to report and started to attempt to intercede. That is how you know their purpose. Erika tried to step in. Children and Family Services on multiple occasions tried to step in. Aniya's own father tried to step in. Daycare workers attempted to intercede. Multiple interactions with law enforcement, never once indicating we have a sick child at home. Never once. Knowingly, again, recklessly or negligently. After Aniya had already had the stroke, you heard the testimony from Dr. Philo. That black eye wasn't at the time of the stroke, it was after. So as she lay in that bed, her pancreas digesting itself, ulcers in her stomach, they were still beating her. That's what the evidence shows you. The abuse was still ongoing even as she was dying. So, what does that tell us? Well, you agree with me that we've established purposefully. If you reviewed all the evidence, then that meets all the mental requirements for counts 1 through 8. Right? Because purposely, recklessly, and knowingly is incorporated into purposely. If you believe they acted knowingly, then you have the mental states for counts 2 through 8. Believe they acted recklessly. You have a mental requirement for count 4 through 8. So where does that bring us? Brings us to the difference between Aniya when she was at Harbor Crest Daycare, Finally, in May of 2017, being taken to the hospital. We knew what she looked like as a healthy child. We have the pictures. To March of 2018, you can see the difference. You can see the difference. Aniya's last days were spent not able to walk, not able to move, not able to do things a normal 4-year-old child could do. Laying in a bed, soaked with her own urine. Laying in a bed, soaked with her own urine. Soaked so far through that the officer testified, the detective testified, you can still smell the urine from the sample, the cutting that they took the day they went to retrieve Aniya and take her to the hospital. That's how we know that every step of the way, Deonte Lewis and Severity Day had every intention for Aniya to die. They knew the harm that was caused to her, and they let that baby linger in this bed. Had the audacity to have an uncle come over and see her, lingering in that bed. Every step of the way, they tried to prevent people from helping Aniya and intercede on her behalf. We are at the point in time where we can end the steps they take. You have the opportunity to intercede on Aniya's behalf. I believe you have more than enough evidence before you. I would ask that you find each defendant guilty on every single count of this indictment. Thank you.
Thank you. Mr. Johnson?
You wouldn't be human if you didn't feel some range of emotions about Aniya. It'd certainly be reasonable to feel a number of different emotions: sorrow, frustration, anger. They'd all be reasonable and they'd all be right. What we said to you, though, when you come into this courtroom, is you have to set that aside for the purposes of this trial. It's okay to have those emotions again once this process is over. It's okay to feel sorrow and anger and frustration once this is over. But in judging this evidence, you have to set aside any bias, any sympathy, any emotion, and look at the evidence as you promised to do in the voir dire. And the job that you promised to do was to hold the government to their burden of proof. Proof beyond a reasonable doubt. We talked about that at some length. And it was read to you again here today. Proof of such a character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. And we talked about those important decisions and the type of things that you would have to decide upon to say that the government had met their burden of proof. I told you in opening statement that they wouldn't prove to you beyond a reasonable doubt that Sierra had purposely taken the life of Aniya, and they haven't. I asked you in opening statement to not make a judgment, and that would be difficult. And I know it was difficult when you look at the pictures that you saw and you hear the evidence that you heard. It's difficult not to close your mind and make a judgment. We asked you to listen to everything, and I think that's what's important. What did you hear in this case? Well, Dr. Philo came in and he testified for you. And we certainly agreed that Dr. Philo was an expert and that he is an expert and that he can give expert opinions. And what did he tell you happened? Aniya suffered some trauma 2 weeks to 3 months prior to her death. And he said it was substantial trauma, and it caused not a skull fracture, not a brain injury, but it left a hematoma, is what he told you. A hematoma that then, after some period of time, developed into strokes. He didn't say it had to be a blow. He didn't say it had to be a punch. What did Dr. Philo tell you? Some amount of force caused this hematoma. It could be a slap. It could be a shake. It could be a punch. It could be falling off of a bicycle or falling off of a playground. And he agreed that it could be any number of things that we could sit here all day long and say, what could have caused that injury? That's not an injury that's designed to cause death. None of the things that that Dr. Philo talked to you about were designed to cause death. A shake, a punch, a bicycle accident, a playground accident. The original injury that started Aniya's medical problems was not something that would be expected to cause death and not something that's designed to cause death. What do we know happens then? And Dr. Philo can only tell you within a range. But what do we know? What did he tell us from right here? He told us that then there would be a gradual decline. I held my hands up like this. And a gradual decline over those periods of months. Fatigue, lethargic, loss of appetite, loss of motor skills, loss of cognitive abilities, a gradual decline. Not a stroke like an older person might have where they get the embolism and they fall right down, but a long, gradual decline. Not a starvation, not a malnutrition, a loss of appetite. Not something where somebody had to withhold food from them. And we're going to get to the point. Should Sierra have called a doctor? Absolutely. Should she have sought medical attention for her child? Absolutely. But there is no blow that causes hematoma that was designed to cause death. There was no willful starvation. There wasn't a cause for that. As Dr. Philo told you, there's a long, gradual decline. And that's supported by Miss Johnson, Sierra's sister. What does she say? I saw a change. She said right there too. What did you see? I saw a drastic change. Things were really good. Things were going along fine. And then there was a change. What was this change? The child began to experience those difficulties that Dr. Philo testified to. And then Erika didn't know what to do. She loves the child. She loves her sister. She calls Children and Family Services. And what does she say? Get that baby help. Get my sister help. When I asked her, does your sister, do you believe Sierra loves Aniya? Absolutely, she said. She saw a change. That's fully supported by Dr. Philo. The social workers that were out of the house in December, what did she see? Aniya playing on a pad, eating popcorn, but she's kind of twitching a little bit, and she's moving and twisting. This is a gradual decline in the loss of her abilities. But it was consistent with what Dr. Philo told us. That this goes on, and it's a gradual, long period of time in which she loses her ability to move, her ability to think, her ability to want to do the things that she used to do. You know, a lot has been made that there's these other allegations from the daycare centers. And go back and look at those. And look at what action was taken, what the injuries were, and what the consequences of those were. I'm certainly going to agree that Sierra, as I said, should have contacted somebody. She should have called somebody. when the things that Dr. Philo described began to happen to her daughter, she should have. What do we know about Sierra, though? And what did we learn through records obtained by the state of Ohio? And you'll have those records. We know that when she was a senior in high school, she was reading, writing, and performing arithmetic between a second and fourth grade level. We know that she functions in the bottom 3% of the population. We know that she was tested and it was indicated that it would be very difficult for her to reside on her own, for her to make decisions on her own, for her to live on her own. Now, the state told you she had a job. She signed 3 leases. She must know exactly what's going on. And you'll have the records, and I suggest you read them, and I suggest you look at how that information got given to you. That information was in the control of the prosecutor's office for almost a year. Yet the detective never even looked at them, was never given to them. There's been much made about Sierra not acting appropriate, or not saying the right things, or not doing things that would be expected, not talking right on the 911 call. But again, when you get those records, look at it. Is there a sinister motive in the things that she said or did? Is there a sinister motive in how she acted or responded? Or is she a young lady that operates at the bottom 3% of our population? Is she a young lady with such cognitive difficulties that she doesn't understand some of those things? And again, there's responsibility there. Should Sierra have picked up the phone and called the doctor? Should she have had medical care for that child? Absolutely. I'm going to ask you, when you look at the evidence, and you look at the charges, and you look at the things that have been presented to you, to find that Sierra did not purposely or intentionally cause the death of her daughter. Thank you.
Ladies and gentlemen, we're going to take a 10-minute recess. Please can I discuss the case? All rise. Not leave the floor. Please do me a little favor. So we probably did like a discovery on this case. But you could get like this. I need you to do a motion to continue trial. And I'm going to dictate it to you. I'm going to really slow. Okay, you know how it all starts. Okay. And hereby moves the court for continuing the jury trial. It is scheduled for March 11, 2019 at 1 p.m. Until she gets to the period.
That's why you make my life so hard. Yes, yeah, yeah, yeah.
Defendant states that Wisconsin
As Mary Jo says, Tom Crest.
will be starting trial in an aggravated murder in Cuyahoga County. Caption, State of Ohio versus Sampson Euclid. You'll need to go up and get the case number. Hughl, period. The Euclid trial is positively commencing at 9 o'clock in the morning with jury selection. And has been scheduled for quite some time.
Correct. I know.
The trial is scheduled to last at least 2 weeks. Period. There is no speedy trial concern for the Benitez case. As the defendant is out on bond and plenty of time exists under Ohio law. Plenty of time exists to try the case under Ohio law. Period. Then respectfully submitted me. Now put it in final and have Mike Marine sign my signature. And then leave it for me because I'm going out there first thing tomorrow morning. Okay? Everything cool over there? We're done. I mean, we'll be done in very short order, yeah. Okay? Thank you.
You sure you
Yeah.
were Monday?
Well, I mean, I took a nice rest this week. I mean, think about it.
Whose room were you gonna be?
We're gonna be in, the clubs.
Oh, okay.
And I originally
You bet.
had thought very long and hard about waiving. And now that I've reevaluated my position, I've spent a lot of time on the file. And so, I may try to figure it out. And so I have one of the defendants, it's Spellacy and,
Jack.
yeah, and you know, they're great guys.
Oh, yeah. Well, McCall was really a good one.
But, you know, I gotta tell you something, I don't wanna, I don't trust one person making a decision on much pressure. And this is a terrible, this is on video. I mean, I'm in the middle of East 28th and Cedar. You see some dude chase somebody across the street and stick a bullet in his back. Hold on, what's it? Hi, Jack. Excuse me, Tom.
Does the rest of them do?
Right. Oh, wait. Just leave.
No, yeah, I'm fine. I'm good.
Yeah, I think that's very true.
Mr. Harms, the guy that filed.
Did they just, did something just come up?
I got 3 trials.
Oh, right.
She should have the compliance coverage sort of.
Right.
No.
Usually they don't want to February, just because
Well, but they should be able to take that position.
Right. I mean, I'm sure they didn't.
I'll find out.
Yeah. Maybe wrong. Right. Maybe they were just trying to get over.
Is there a reason opposition to the motion to stay?
I don't. No, we didn't, we never had the application. Yes.
No problem with that.
I'll make sure that not as a. There.
Saw that the person just didn't have long. He's been older before you. Scary. Okay.
We're gonna have to do
Yeah, that's what I saw.
and they never put the,
Don't sit there, they put a coffee in my mouth.
Yeah, I want them to tell me if they want to go down. Oh, just put it back.
turned it up a little bit. I don't know if it helps.
A lot of them.
Right. Oh, but can I tell you this? I have to tell you this. Come on.
Oh, they're all here, I'm sorry. You see it.
All rise for the jury.
You may be seated. Ms. Longino?
Ladies and gentlemen of the jury, I won't be using this thing. I'm old school and I don't know how to work this giant iPad. Okay. So I have to go with pen and paper. Now, before I get into my basic argument, I just want to comment on the fact that the prosecution talked about how it was March in Miss Day's apartment and the air was on. It's March now, and the air is on in this courtroom, and I'm freezing. Well, some people just get hot, you know, so they get hot, and it's hot in the house. They turn the air on, and maybe, you know, they're young. Maybe even they thought that the air would help revive the child or something to that effect. So I don't think there should be much made of the fact that the air was on. Also, Ms. Jordan said it was 3 minutes and 50 seconds before in the 911 tape, before they said that this child was not breathing. Well, I take issue with that because Deonte Lewis on the 911 tape, if you recall, first thing he said is, and he did say my daughter, but that is more of a term of endearment. I mean, if you're calling in an emergency situation and you say, you don't want to say my girlfriend's daughter, you want to say something that's going to get their immediate attention, and you say my daughter, then that lets them know that this is important to him. I need you here now because my daughter is unresponsive. I tried giving her CPR, but I don't know if it's working. I press on her chest, I hear noise, but I don't know exactly what's wrong. I need somebody here now. Okay, now, let's talk about when EMS arrived. The first EMS person, well, they both said that they were trying to get in the door. They had to make several attempts to get in the door. But the first EMS person, Mr. Lupa, Nate Lupa. He admitted when Mr. Shaughnessy got up and said, you beat on the door, fire, 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 fire. And then Mr. Lewis opened the door. And so he admitted, yeah, he did. The other one, I think he said, took him 30 seconds. And then everybody want to make, something about the fact that it took them 30 seconds and then they got in and the place was clean and they smelled bleach. So I guess they're trying to imply in 30 seconds they grabbed some bleach and start trying to clean the place up, which is ridiculous because there was already testimony that this child was not bleeding. There was no blood to be cleaned up. And what is so strange about this young woman having a clean apartment? I believe if her apartment had been dirty, they would have made that an issue. But they want to make an issue out of the fact that this young lady had a clean apartment. If you recall, the social worker also said when she went there, she had a clean apartment. So I think that's a plus, that this young lady was conscious enough to make sure she kept her apartment clean. Also, I think it's noteworthy that when Patrolman Jeffrey Harold testified, he said that when they brought Aniya out of the house, her limbs were dangling. And if you can recall, some of the EMS workers and other police officers were saying, well, they thought rigor mortis had set in already, like this child had been dead for a while. Now, you heard Dr. Philo testify that when rigor mortis sets in, the limbs are stiff. But Patrolman Harold said when they took her out, her limbs were dangling. So that lets you know, you heard me, I challenged every last one of them. Are you a medical professional? Are you a doctor? Do you have a medical degree? Are you qualified to determine and diagnose time of death and cause of death? And they all had to say no. But Dr. Philo got up here and told us what the cause of death was, and that was the stroke. I got the medical term written down, but I don't feel like looking for it. But you heard his testimony. And that when rigor mortis sets in, the limbs are stiff. Okay. Now, also, the paramedics and first responding officers, they all had something to say about, well, he said this and she said that, and he said this and she said that, meaning Mr. Lewis and Ms. Day. And I asked them, did they memorialize it in writing? And the only thing that Mr. Lupa had memorialized in writing about what was said is that the mother said the child fell off the toilet last night, hit her head, but was okay, went to dinner, no other information given. Now, Mr. Lewis obviously didn't tell them that because he didn't know what happened to this child. He wasn't there. They have gone through unreasonable lengths to try and say that these two defendants lived together. And what proof did they have that they lived together? Her brother said he saw Mr. Lewis over Miss Day's house a couple of times at Harbor Crest, one time at Cultural Gardens. His sister said she never even went over to the apartment, so she didn't see him there. She just saw them together all the time. But if you can recall, the sister and Miss Day stopped speaking to each other in September. We know that Mr. Lewis and Miss Day got together in July of 2017. In September of 2017, Miss Day and her sister stopped talking. So in the first 2 months, she saw them together all the time, but she never saw him at her apartment. She just assumed they lived together because she saw them together all the time. So I questioned Sierra's twin brother, who is still a young man. And I said, isn't it reasonable that when people get together in the beginning, or young couples get together in the beginning, they spend a lot of time together, they can't get enough of each other. They get together and do things young people do and some things old people still do sometimes. He admitted it. He said yes. Okay. And when else did the prosecution cite that that Mr. Lewis was at Ms. Day's apartment? They cited a total of 7 times in the 9 months that they were together. Of course they spent time together. Of course he went over to her house at times. But 7 times in 9 months proves that he lived there. He did not live there. When he gave his statement to the police and put his address on there, he gave his address in East Cleveland at his parents' house, which is where he lived. He lived with his parents. He visited his girlfriend, of course, but he lived with his parents. The officer also said that he told them he was a stepfather. He never wrote that down. He never presented himself to be this child's stepfather, except that one time on the 911 tape when he said, "my daughter." And his motive behind that was to get them there as soon as he could. He never held himself out to the public that this is my child. When he would go, and that's another thing, with the daycare workers testified, when he would pick, I don't think any of the Harbor Crest daycare workers testified that he picked her up. I believe it was only at Get Ready, Set, Grow. And Get Ready, Set, Grow, the lady's name was Chantel Milton at Get Ready, Set, Grow. And Chantel Milton said, I asked her, I said, approximately how many times did you see him drop her off? Between November 2017 and January 2016. About 8. Well, 8 times in 12 weeks is less than once a week. If he was living there, she would have seen him many more times than that. So once a week, he spent the night over his girlfriend's house, dropped the baby off at the daycare. That doesn't make him her stepfather. That doesn't make him somebody in loco parentis. And that doesn't make him a resident at her apartment. And you heard the testimony. I believe Shakia Fitzpatrick said about the same thing, that she would see him drop Aniya off about once a week. Now, every last one of the daycare workers, from Harbor Crest to Get Ready, Set, Grow, every last one of them, I asked every last one of them, did Aniya ever say to you, Deonte or Noodle hurt me? She called him Noodle. Every last one of them said no. As a matter of fact, they had 38 witnesses, and not one of them testified that Mr. Lewis had ever harmed this child. As a matter of fact, Miss Day's own family, her brother and her sister, said they had never seen him lay a finger on this child. I asked her sister, Erika Johnson, did you ever see him take her into another room and bring her out crying like she had said she saw her sister do? She said, no. Nobody ever witnessed him harm this child because he never, ever did. Michelle Marshall from Harbor Crest, She was a very nice lady. And she got emotional and she started to cry when she talked about Aniya and her injuries. And she said that she saw Aniya in June of 2017 and that Aniya was fine. Now, the daycare workers from Get Ready, Set, Grow. I believe Aniya started Get Ready, Set, Grow in November of 2017. So by now, Deonte and Sierra have been dating for about 4 months. They all testified Aniya was a happy, healthy child. Chantel Milton, she said that the last time she saw Aniya was on January the 16th, and that Aniya walked into the daycare. So January 16th, she was still walking, and she was a happy child. Mr. Day would drop her, Mr. Lewis would drop her off. She was a happy child. So evidently, she liked him. If she didn't like him, she wouldn't be happy with him, that's for sure. Because kids will let you know. One thing about children, if they tell you something, you better believe it. Because they don't have a reason to tell you something that's not true. They are the ones, sometimes adults will tell you something, tell you a little lie to make you feel better, don't want to hurt your feelings. Kids don't care. I know my grandkids don't care. They'll tell you if something's wrong. She never, ever, ever told anybody that Deonte Lewis harmed her. As a matter of fact, it seems as though when Deonte Lewis came into Miss Day's life, things got better for Aniya. She was healthy, happy, going to school. And we all know that in daycare, they feed children properly. They have to feed them properly. And so her health was good. Her weight was good. And even in September of 2017, when Mr. Garrett, I know you recall his testimony, when Mr. Garrett said he had noticed some marks on his child, he asked Aniya what happened. She never said anything about Deonte Lewis, never. She never said anything about noodles. As a matter of fact, Mr. Garrett said he did not even know that Deonte Lewis was dating Miss Day until his daughter's demise. He hadn't heard anything about him. He didn't know anything about him. So if they were living together, surely he would have known something. He would have heard about him. Aniya would have spoken about him, something. But Mr. Lewis was in and out. He was in and out. As a 28-year-old man, they do what 28-year-old men do. Those are not married. The single 28-year-old men, they like to party. They like to fool around with other chicks. They like to hang with their boys. Those were things he was doing. But, he had a girlfriend. So he would go be with his girlfriend from time to time. And she had a daughter. So sure, he would reenact with her daughter. But he was not there every day to monitor what was going on in their lives every day, to monitor Aniya's feeding schedule every day, or to monitor what was going on with her physically every day. Now, seemingly the frequency of the visits stopped somewhere around September. But like I said, he was still in and out, in and out. And they wanted to make something of the fact that when Miss Day moved from Harbor Crest to Cultural Gardens that Mr. Lewis helped her move in. That was her boyfriend. If I had a boyfriend who wouldn't help me move, he wouldn't be a boyfriend very long. And just because he helped her move doesn't mean he was moving in there with her. The guy who helped him move the couch was the lawn man. I believe his name was Mr. Bailey. If I got his name wrong, excuse me, but I believe that was his name. But anyway, he said that he helped him move in, and that was the only time he saw Mr. Lewis. And he lived right next door. I think he lived in 215, and Sierra Day lived in 212. He only saw Mr. Lewis that one time. He didn't see Deonte in and out and in and out. And then Miss Logan said she heard them upstairs arguing and stuff, and she saw him about 3 times in and out. How on earth does that prove he was living with her? It does not. It proves that he was not living with her. He was not acting in loco parentis to her daughter. He did not assume parental responsibilities of her daughter. He was her boyfriend. Why was he arrested? Because he was there when this child passed. And he called 911. He went over there on the 10th. Okay, they shot across the street to Chipotle. You heard the testimony. The detective even said it was right across the street. He went right across the street to Chipotle with her. He went to the grocery store with her on the 10th. They went back to the apartment. They got evidence that they had sex in the apartment on the 10th. On the 11th, he gets up, goes in the room, finds this child unresponsive, finds that he has to administer CPR, and calls 911. Now, Dr. Philo was unable to pinpoint, well, let me go back. If you can recall Dr. Philo's testimony, he said that by the time he got the child's body on March the 12th, she had been deceased approximately a day and a half. Okay, now that logically follows if the child passed sometime on the 11th, say the early hours of the 11th. Dr. Philo gets the body on the 12th in the afternoon. I think it was 1:10 in the afternoon. That's about a day and a half. So this child, it wasn't like she was expired and they just had her in that house expired and they went to Chipotle and they went to the store and that the picture the prosecution is trying to paint, that is inaccurate. If he got the body on the 12th and this child died early morning of the 11th, that's about a day and a half in time. Dr. Philo also said that first he said she sustained a fatal blow 2 weeks to a month or 2 months before she passed. When Mr. Shaughnessy cross-examined him, Mr. Shaughnessy asked him, could it have been a week? He said, yeah, it could have been a week. More likely 2 weeks, but it could have been a week. So he could not pinpoint when this child sustained this fatal blow. He could not pinpoint what the source of this fatal blow was. And going back to the times that the prosecutor puts Mr. Lewis at Miss Day's apartment, I believe the first was February 21st. And then there was a gap between February 21st and March the 10th, where they could not place him there. So it logically follows that in between that time is probably when this child suffered this fatal blow. Now, Mr. Lewis couldn't tell you today what happened to that child. He was not there. He was not there when she sustained that black eye. I believe that Dr. Philo said that occurred maybe a couple of days prior to her death. But he was there one day before her death. And prior to that, he wasn't there between February 21st and March the 10th. So he had no knowledge of what happened to this baby. He couldn't tell you what happened to this baby. If he had not been there when Miss Day called, or if Miss Day had called 911 and he was not there, he would not be sitting at that defense table right now. He would not. But he did not abandon her. When he discovered that her child was non-responsive, he did not abandon her. He called 911 to come and get her. Now, the prosecution says, oh, this child suffered for months and they just watched her waste away. Well, Sierra's brother saw her a month prior there too. He saw the baby a month prior there too. And what did he say? He said she was, and I'm quoting him, cool. He said that this baby was cool, that she was okay. And the only thing wrong was that she could not walk. Now, I agree with Mr. Shaughnessy. Her mother should have taken her to the doctor to see why she could not walk. But why are they trying to charge that responsibility to Mr. Lewis? That was her mother's responsibility. And he probably trusted her to make the right decision for her child, to seek medical attention for her child. Well, if he'd have swooped that baby up and took her to the doctor, somebody might have charged him with kidnapping. He took her without my consent. He took her against my will. That's kidnapping. He couldn't do that. He had to let the responsibility lie where it belonged, and that is with the mother, to call or take her child to the doctor to see what was wrong with her and why she couldn't walk, or however she sustained that blow to her eye. Her mother should have taken her to be medically attended to see what was her problem. Mr. Lewis never harmed this child. There's absolutely no evidence that Mr. Lewis ever harmed this child. Now, I'd like to go through these charges. Aggravated murder. Now, if you recall in my opening statement, and just for just for a point of reference, I know in the opening statement, I said that Mr. Lewis had to go downstairs and open the door, let the paramedics in. Well, I was mistaken. I was wrong. Evidence has showed that the fire department had a key to open the downstairs door. So that was my mistake. That was my bad. Please do not hold it against my client. But in opening statement, I asked each of you, I said, the prosecution has to prove beyond a reasonable doubt each and every last element to each and every last crime with which my client has been charged. Every one. And I asked you if they could prove 3 and couldn't prove number 4, you have to find him not guilty. And I asked each and every one of you if you were okay with that, and you all said yes. And I trust that you meant that. Now, aggravated murder. Purposely caused the death of Aniya Day. To purposely do something, that means you do it with a specific intent. Okay, you specifically intend for the results of your actions to come about. Causation is another element in this crime. And causation was defined to you as an act or failure to act within a natural and continuous sequence that directly produces the death of a person. Okay. First of all, Mr. Lewis had no way of knowing that this child was dying. He had no way of knowing that. Her own uncle thought she was cool a few weeks before she passed. So, in order to find him guilty of aggravated murder, you have to find that he either did something to cause the injury that killed her, or that he failed to act to prevent this death, but that he did it on purpose, that he purposely intended for this child to die. And that's why he didn't call 911 before he did, because he purposely wanted her to die. That element does not exist. He did not want this child to die. That's why when he found her unresponsive, he called 911. He wanted to save her life. That element does not exist. So that charge, that finding, I submit to you, ladies and gentlemen, has to be not guilty. The second charge is murder. That the offender committing or attempting to commit offensive violence that is a felony of the first or second degree, to wit, felonious assault, endangering children, or committing child abuse. Now, none of those elements exist because he did not commit any act of violence against this baby. Not once. He never laid a finger on her. Now I'm going to go to felonious assault. Knowingly cause serious physical harm to Aniya Day. Okay, there's that word cause again. That also has the words failure to act within it. But you have to knowingly do these things. Knowingly. He did not know that this baby was dying. And you saw the pictures. The pictures were of this child unclothed. Now, it's reasonable to assume that the baby didn't go around naked, going through the house naked all the time, so he could see what was going on under her clothes. She was clothed when he would see her. He couldn't see these protruding bones and her skeletal state. And I agree, she was in an emaciated state. I agree with that. But her face did not show signs of her being emaciated. You saw the pictures up here, and you will take pictures in the back, and some of those pictures, the lighting is bad, and there's shadowy parts that do not depict what you saw on this screen. But her face, if all he's seeing is her face and her clothes or her PJs or whatever, to the untrained eye, he would have no way of knowing this child was dying. Her own uncle didn't know she was dying. How is he charged with supposedly knowing that this child was dying, but no one else? No one else. You know, well, mom, I don't represent mom. I can't speak for mom. But there was no way for him to know by looking at this baby's face that she was dying. So he did not knowingly. Her face wasn't sunken in, skeletal. Her face didn't look like that. Rest of her body, her face didn't look like that. And the red scabs that were on her legs were bed sores. You heard Dr. Philo said he couldn't really tell. He said they didn't have like a pattern where he could say somebody burned her, so he ruled out the burn, but he said they were probably bed sores. Okay. Is Mr. Lewis supposed to be responsible for that? He's over there. He hadn't been over there for weeks before he went back on the 10th and then woke up on the 11th and found this child dead. Well, found that she was unresponsive, called 911, hoping he could save her life. Is he responsible for the fact that mom let her lie in that bed and develop bed sores? I submit to you, ladies and gentlemen, he was not. So the element of knowingly cause physical harm to Aniya Day does not exist. So that charge should have a finding of not guilty. Permitting child abuse, count 4. The defendants did being the parent, guardian, custodian, or person having custody of a child under 18 years old. He certainly is not her parent. He's not her guardian. Guardian is defined as any person appointed by the probate court to have the care and management of the person, the estate, or both of a minor. He certainly was not that. He was not her custodian, which means one entrusted officially with custody. He was not that. Those elements do not exist. Therefore, the verdict for that charge must be not guilty. Count 5. Endangering children. A child under 18 or a mentally or physically handicapped child under 21 years of age recklessly abused the child. So in order for him to be found guilty of endangering children, you have to find that he recklessly abused this child. He did not recklessly abuse this child. He did not purposely abuse this child. He did not intentionally abuse this child. He did not accidentally abuse this child. He did not abuse this child in any shape, form, or fashion. He did not. That element does not exist. So for that charge, you must find him not guilty. Cause serious physical harm. Again, he never harmed this child. Not seriously, not minorly, not in any way. That element does not exist. Endangering children. In order to find him guilty of this charge, you have to find that he recklessly tortured or cruelly abused this child. There's no evidence that he ever did any of those things, that he ever tortured this child, he ever abused this child in any way, form, or fashion. That element does not exist. Therefore, count 6 must be a verdict of not guilty. Endangering children. In order to be guilty of endangering children, you have to be the parent, guardian, custodian, person having custody or control, or person in loco parentis of a child, and recklessly create a substantial risk to the health or safety of that child by violating a duty of care, protection, or support. Well, he's certainly not her parent, not her guardian, not her custodian. He did not have custody or control over her, and he was not in loco parentis. And loco parentis, you've seen the definition. It is defined as someone standing in the place of a parent and assuming parental duties or responsibilities. Now, calling her his daughter on the 911 tape to get them to hurry up and come see about her, dropping her off at daycare occasionally, does not put him in the place of her parent or assuming parental duties or responsibilities. You don't have to be a parent to drop a child off at daycare. So anybody who drops the child off at daycare, they're in loco parentis? No. And loco parentis, typically it would apply to a daycare center, somebody who's put in custody and control of a child and has a responsibility to make sure that this child is taken care of properly. That was the responsibility of Ms. Day, not Mr. Lewis. He would do what he could for this child, but this child had a father. The father always wanted to be in this child's life, more than willing to take his place in her life. My client wasn't trying to substitute that. Never. There's been no evidence to show that he ever did that. Those elements do not exist. Count 7 must be a verdict of not guilty. Count 8. Alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. What are they talking about when they talk about a lineup of cleaning agents? What is that all about? Just because she had her cleaning agents lined up on a counter does not mean that she was trying to use them to destroy some kind of evidence. That is absolutely ridiculous. What did they try to destroy or alter? What? Nothing. Because she keeps a clean house. If she kept a dirty house, they try to use that against her. Now, because she keeps a clean house, they're trying to use that against both of them. That charge is ridiculous. There's no evidence that Mr. Lewis tried to destroy any documents or anything else to impair an investigation. Count 8, because those elements do not exist. Count 8 must have a verdict of not guilty. Now, it was brought out that on 5/17, when the child was going to daycare, she weighed 32 pounds. At the time of death, she weighed 26 pounds. That's a gradual loss of 6 pounds over a 10-month period. I don't get it. A child loses 6 pounds over a 10-month period, and they want to say that she was starved? She was emaciated. I don't disagree with that. But she had to be a very thin child to start with. But like I said, Mr. Lewis wasn't there to monitor her feeding schedule. It was not his responsibility. And he wasn't there to do it. I would submit that if he did live with Miss Day and he observed these changes, then, and he was in local parentis, then maybe he would have convinced her to take this child to the doctor. But that wasn't the case. So he had to rely on her judgment as this child's mother to do what was right for this child. And I submit to you again, ladies and gentlemen, that seeing this child fully clothed and not seeing her skeletal body and seeing her lying down with a black eye is not enough to say that he should have known she was dying. Because Dr. Philo said these. Okay, thank you, Honor. All right. I submit to you, ladies and gentlemen, that in order to convict my client, you must find beyond a reasonable doubt each and every element of each and every crime with which he's been charged. And A means one. One reasonable doubt. And you are committed by virtue of your oath to find him not guilty. I thank you for your service and your time. Thank you.
Ms. White? Everybody all right?
Counsel for the state, Detective Krozak. Counsel for the defense, Defendant Lewis and Defendant Day. May it please this honorable court. Good afternoon, ladies and gentlemen. Our journey of the last 6 days is coming to an end. And we, as advocates for our respective sides, our jobs are coming to an end. And make no mistake about it, ladies and gentlemen, each person in this room had a job. Your job is just beginning. Though you have toiled with us these last 6 days, you have been here patiently, you've taken notes copiously, you've withstood the objections that have been made, and we've gone to sidebar, and you've listened attentively. You have been true to your oath. And now, ladies and gentlemen, once the conclusion of the instructions are given to each of you, it's going to become your job to evaluate the evidence. And that's going to be the testimony, the exhibits, the stipulations. And you've been selected to render a verdict in this case. Like it has been said before, opening statements and closing arguments are not evidence, but they are provided to give you a perspective of how we see the evidence and how it's developed. But I ask you folks to rely on your 12 collective memories. I ask you to recall the testimony in this courtroom. And it's the testimony that came from this witness stand. That's where your evidence came from, along with the exhibits you're going to have. It's not what the attorneys say. That's not evidence, folks. And once you've reviewed that evidence, you've weighed, you've applied the law that this court has given to you. The state asked you in opening statements to make a decision in this case, and I'm going to ask you at the conclusion of my argument to render a verdict on each and every count of this indictment. Juries make these decisions every day, all throughout this building and throughout the United States of America. In voir dire, I asked you folks, did you have reason and common sense that you have in your everyday lives? And good judgment. And you all said that you did. And you all said that you'd bring that into this courtroom. That's what I'm asking you to utilize in your deliberations. You all the sole judges of credibility in this case. And as was said to you, you can believe some, all, or none of what was testified to. You can consider the body language, the candor or lack of candor, the motive or the bias of which one testified. I submit to you, ladies and gentlemen, it's not about the number of witnesses we presented or the exhibits that you're going to have to look at. It's about the quality of the evidence that was presented to you. And that quality of evidence, can you rely upon it in the most important of your affairs? Reasonable doubt. And the judge gave you that definition. Hold me to that definition, folks. That's all I ask. It's a fair playing field. Reasonable doubt is used in a theft case, and it's used in an aggravated murder case. It is the same standard. The state of Ohio had the responsibility to provide to you folks and accounting for the death of Aniya Day. Aniya Day was a 4-year-old child that lived in this community, just like me and you. And as a prosecutor, we have an obligation to prosecute cases against folks that violate the criminal code. That's what we have here. We have 2 adults, ladies and gentlemen, and I think we can all agree that Aniya Day did not kill herself, that she didn't starve herself, that she did not cause blunt force trauma to be placed to her head. And anybody that tells you any difference, then you need to look at that. You need to consider that against what the fact is. This child died because of blunt force trauma. And that trauma caused a subdural hematoma. That trauma caused several strokes. In addition to that trauma, folks, she was starved to death. And I don't care if she had layers and layers and layers of clothes on her. Anybody that has a heartbeat, that has 2 eyes and a mouth, could see what was going on with this child. So putting on blinders doesn't belong in this courtroom. Aniya Day did not take the witness stand. She talked to you through each and every injury she suffered and that somebody witnessed. She started asking for help after the first black eye, the busted lips, the bruised eye, the scab on the head, the scab on the nose, the scrapes on her head, the blood in her ear. She was asking for help. And initially, she was in the care and custody of her mother, the same woman that gave birth to her, the same woman that the defense wants you to believe she doesn't have the mental capacity to raise her kid. The same woman that broke up with her boyfriend, the father of her child, got herself an apartment, got herself a job, got herself money. She was getting her paycheck and child support, able to go to the store, able to take her daughter to the doctors, able to take her daughter to the dentist. Is that somebody who can't function in society, folks? We were in the same courtroom. You consider the evidence you heard. This is what I heard. I'm not imposing it on you, but I want you to pay attention to the evidence, because that's what it's about. It's not about the woulda, coulda, shoulda, because that doesn't belong in this courtroom. Daycare workers were concerned, so they wrote up observations of this child. CCDFS was contacted. And so when Mr. Shaughnessy wants you to believe that, you know, she's got a 3rd grade reading comprehension, I submit to you she's a master manipulator, because every time that somebody contacts Children and Family Services, what does she do? She isolated her daughter. They make a claim in February of 2017 about a bruise under her eye. Oh, she fell at the park. She fell at Grandpa's house. She hit the table at Grandpa's house. Clumsy child. Master manipulator. So finally in May, Harbor Crest, those social workers couldn't take it anymore. The daycare workers, excuse me. And what do? They call 911. They have that child taken to the hospital. Scrapes on her head, bleeding in her ear. And what's the little girl say? Mommy did it. Well, that's not good. Now Harbor Crest has now reported me. Again, master manipulator. Let's get her out of Harbor Crest, and we're going to move her over to Get Ready, Set, Grow. So what happens then? Well, then this love affair happens, folks. And it's the testimony that you heard. It's not a few months that they were dating, according to Miss Longino. They started dating in June of 2017. And you heard Isaiah's testimony. Isaiah's testimony was, and I quote, he was underneath her. He was possessive to the exclusion of others. And that, ladies and gentlemen, says it all. Because a child loves their mother. And you heard Erika Johnson. She said her sister changed when he got into the picture. Not Aniya, when he got into the picture. And they started spending time together. Together. That's what the evidence shows. He attended some family functions. And I, by no means, am going to go through all of the testimony of all of the witnesses. Okay, I'm not going to do it, folks, because I rely on you guys. And you've all been paying attention. But keep in mind, when Aquila had on her PowerPoint, how many times this defendant was present in this child's life. It wasn't just on 4 or 5 occasions, folks. He was there the whole time. And make no mistake about it, because you heard Mr. Garrett, he calls the police in September of 2017. They were already dating. And he sees the bruises and the problem in the back, scab on the back. There's photographs, look at them, consider them. So what does he do? He calls the police. Lo and behold, Miss Master Manipulator over here, well, he can't be calling the police. They're questioning us about what's going on with Aniya now. So what are we going to do? I'm going to get a protection order. I'm going to march myself right down because I don't know what I'm doing, but I know enough to know I can get a civil protection order. And I'm going to say that you, Mr. Garrett, are abusing me and my daughter, harassing us. I'm going to get a restraining order because then I can guarantee you're not going to see your daughter again. Reason and common sense, ladies and gentlemen. And then you have Erika Johnson. She takes it upon herself to contact CCDFS on her own sister because she hasn't seen her sister and she hasn't seen her niece. And I submit to you the reason she hasn't seen her niece and her sister is because the 3 of them had set up shop at Harbor Crest. And they were all living together as one big, damn happy family. The only person that wasn't happy in that equation was Aniya. Because there came a point in time, ladies and gentlemen, that regardless of who struck her or where the blow came from, this child suffered a blow. And I submit to you, they are equally culpable for that blow. One is not more responsible than the other. Once she suffered that blow, that child started to deteriorate right in front of their eyes. As human beings, we nurture people that are ill. We spend hours at hospice centers watching people die because we love them. We don't let them be alone. But these two, they don't have a heart or a soul for what they did to this child. Torture and cruelly abused. And she has the audacity to say, find him not guilty? Are you kidding me? Not so much as a glass of water. She couldn't talk. She couldn't tell you what she was going through. The only thing she knew is lying in a bed, soaked with urine. That's what she knew. And those were the end of her days, lying in a bed, soaked with urine. Meanwhile, their life went on. We have a dispute, so we go back to Harbor Crest for a mailbox key. We go out at night in February in the dead of winter. Last year was bad, folks. And they go to the hospital because they're cold and they want to ride home. At 4:30 in the morning, they're together in tandem. He's not going back to anybody else's house. And by the way, where's their evidence that he was staying at his mom and dad's house? There's no evidence to that. Did it come from this witness stand? No. So you've got 2-1, moves into Cultural Gardens. He's moving in the sofa and Mr. Bailey's helping him. No child was around. February 9th, there's a domestic dispute. She throws his clothes out the door. But keep in mind what she says to the police officers. Ma'am, we can get you a no trespass order. Oh, that won't be necessary. Because she wants him to come back. Reason, common sense, good judgment. I'm not asking you to create something, folks. I'm asking you to take what you have, apply the law, and come to the only just verdict in this case, which is that of guilt. 211, they're driven back to Cultural Gardens from the ER. And then they even admit, oh, we lied about 2 black guys chasing us because they wanted to ride home. 221, report of a tablet being stolen by him. They're living together. Who are they kidding? Isaiah comes in and he says that his sister says the little girl's not walking. So they know in February. Miss Longino wants you to believe that, oh, lo and behold, he comes over Saturday night, the little girl's in bed, and they wake up the next morning and they call 911. It didn't go that way, folks, because they don't call 911 until 3:30 in the afternoon after they had to get their story straight. Because now the child died. And she was dead, I submit to you. When that paramedic picked her up, she was in rigor. On 3/8, they're at Harbor Crest arguing about this mail key. On 3/10, they're obviously, the child's dying in the other room, and they're on the couch. fooling around, and it's not even bad enough. Have the audacity to videotape it so they can keep a memento. And then they go to Chipotle, and that same food is in the microwave. That's what's called evidence. The videotape, that's evidence. They're together. And the air conditioner, really? Why do you think they have the air conditioner on? It's about reason and common sense. It is the smell of death, ladies and gentlemen. That child died. Rigor mortis and lividity set in. And tell me why. Why did she need to have another black eye before the authorities found her dead? What did she do to deserve another black eye? Did she moan too loud? Did she pee too much? Did she expel any feces? Is that what determined that she deserved another blow 2 or 3 days before she died? It's about reason and common sense, folks. You were in this courtroom. You heard the testimony. Isaiah said he went to Cultural Gardens once. He had been there more than once. The evidence shows he was there multiple times in February because he was really living there, folks. Make no mistake about it. And then Miss Longino wants you to believe that it's just the mother's fault. He really didn't see anything. She was covered all the way up. The only thing she saw was her face. Look at her face. Look at that big brown, black and blue eye, the laceration. And look at her body. Do you really think they were washing her clothes that were soaked in urine every day? I submit to you, no. That would have been a bother. So they kept her in a diaper. And you'll see the photographs of the inside of the house that is so pristine and clean. So the least they could do was change your diaper. Look at the 911 call. It came in at 3:30 in the afternoon, ladies and gentlemen. And we're here because of what they've done. And this is what they tell the police. And you're going to have these back there with you. This is Deonte Lewis's. Family went to Red Lobster after that, started to act weird. Acted like she couldn't walk. Didn't want to eat. She just started acting non-responsive today. Before today, she talked. She would eat. But when she wouldn't eat, we gave her Tylenol. And she didn't want it. Really? Reason and common sense. And then the mother. Family went to Red Lobster. Daughter ate food, got home, started acting really weird. Noticed she didn't want to go to the bathroom or eat. Every time we feed her, she threw it up. Gave her ginger ale, she threw it up. Put daughter on toilet to use it. Daughter wasn't responding at all for I believe it may say minute. You'll have to determine what that says. Heard a boom. In bathroom, daughter was on the floor, picked her up, did CPR. She started to respond back, led her down I don't know what the word is, went past daughter, still acting weird, gave her more ginger ale, threw it back up, tried to give her more food, threw it back, gave my daughter Tylenol, threw it back up, stopped breathing, did CPR. Not once does she address her as Aniya. Not once does he address her as Aniya, because to them, she was already dead. At the end of the day, ladies and gentlemen, as the case is winding down, we recognize that in a civilized society, we rely on the recourse of the law. We owe it from one generation to the next. The recourse of the law requires that you find truth. In finding truth, it really requires that you have faith in yourselves and faith in the law. What your decision will be in this case completes the accounting for the death of Aniya Day. These families have been on this journey for over a year. They're looking for the truth as well. What happened to Aniya Day? In solace, ladies and gentlemen, there is truth. I'm going to share with you a poem. The meaning of being a mother is virtually endless. A mother is a protector, a disciplinarian, and a friend. A mother is selfless and loving, a loving human being who must sacrifice many of her wants and needs for the wants and needs of her children. From the day they are born, a child will test your patience, no matter what they do or what they say. Being a mother means you will love your child unconditionally. When a woman becomes pregnant, it is her responsibility to provide a safe and secure environment while her baby grows. This responsibility, ladies and gentlemen, continues once she becomes a mother. Whether it's ensuring her child has a roof over its head, to keeping the monsters away at night, and everything in between. Ladies and gentlemen, Sierra Day failed miserably in her care of her only child. Deonte Lewis failed miserably as her stepfather, her father, or whatever title he gave himself. And he failed as a human being. Anybody that sees those photographs would have called for help. Regardless, social workers called for help when they saw a bruise. Have they seen her 12 ribs and counted both her pelvic bones, her hip bones? Don't you think they would have called too? Ladies and gentlemen, the accounting for Aniya Day is at an end. What you do in the next couple of days is up to you. The effort and time in evaluating all the evidence, the witnesses, and the exhibits is important. apply reason and common sense that you use in your everyday lives. Use that same reason and common sense that when you raised your hand and said that you would truly try and true deliverance make between the state of Ohio and these two defendants. Keeping in mind, ladies and gentlemen, that it is your duty to arrive at the truth. Because only at arriving at the truth and arriving at a just verdict, holding these two responsible for the death of Aniya Day, will Aniya rest in peace. Only with the truth can justice be done here, folks. I ask you, I implore you, we have given you all the necessary tools to make a decision in this case. You can make a decision in this case, however distasteful you may think it is. These two people caused her injuries, and then these two people watched that child wither away. And to say it was only 6 pounds is offensive, ladies and gentlemen. That child was starved. Make no mistake about it. That just didn't happen. She didn't do it to herself. These two people, and really, dare I say, human beings, because they have no heart and no soul for what they did. And for that, you need to find a verdict of guilt on each and every count of the indictment. Thank you, folks.
Ladies and gentlemen, you will have the instructions as I indicated back with you for reference. The ones that were read at the beginning are in the middle, the ones specific to the charge will be on the right-hand side. You also have the verdict forms, which are self-explanatory. For instance, count 1, aggravated murder. We, the jury in this case, being duly and panel sworn, you find the defendant, Sierra Day, you either assert guilty or not guilty of aggravated murder as charged in count 1 of the indictment. There's 12 signature lines. The foreperson shall sign on the first line, the other 11 will sign on the other lines. Obviously, does not have to correspond to your seat assignment. On count 2, there's further findings if you find the defendant guilty on count 2 of murder. Either defendant, you then go to a further finding as to what the other offense of violence was, i.e. felonious assault or committing child abuse or endangering children, but it's self-explanatory. If you find not guilty on that count, you then don't have to go to those further findings. Obviously, since this is a criminal case, all 12 must be in agreement to have reached a verdict. Your first order of business is to select a foreperson. The foreperson has no greater say in what the verdict should be. The foreperson is charged with the responsibility of making sure that everybody has the opportunity to participate in the deliberation process. Additionally, if any juror has a question, the foreperson shall write that question down. The foreperson shall sign his or her name. You'll ring the bell, my bailiff will get it. She'll bring it to me, I'll review it with counsel. I cannot have any direct communications with you, nor can my bailiff answer any substantive questions regarding this case, obviously. You can take breaks anytime you want, but you can only deliberate when all 12 are in the jury room. All the exhibits will be with you back in the jury room. So if something's missing, or you believe something is missing, that might have been referred to during the course of the trial, and it's not back there, it's either because it was either not offered in evidence or accepted in evidence. You'll have no testimony read back to you. We cannot cherry pick different portions of testimony. You have to rely on your collective memories. You'll have a laptop with you. I believe there might have been a video or two. You see the pictures rather, I guess. I'm going to ask that the Alternates return to the fourth floor. You'll give your phone numbers to my bailiff. I'm going to ask that you stay until the jury is discharged for the day. And I'm also going to ask for you to return tomorrow. So as far as you're concerned, you're still on jury duty, just in case we have some sort of emergency. We would then bring you and put you in on the jury. I would ask that you not discuss with anyone what your verdict would be until the jury has announced their verdict. And obviously, we'll bring you up for the verdict. So you have the ability to listen to the verdict. Any questions, counsel?
None, Your Honor, thank you.
No, Your Honor.
Very good. We will have the exhibits back to you momentarily. All right.
Judge, the jury believes we need to.
Oh, okay.
Judge, there's a typographical error too they find.
Your Honor, on the verdict forms under the further findings for count 2, after the blank line, the word guilty is included. That just needs to be deleted so they can fill it
I'll
out.
just cross it out.
Thank you.
On the verdict form, count 2.
The further findings.
Further finding on count 2. Sure. Okay, I'll put them on the side. We'll put them right there. Put them on the side.
I see that.
The judge want you to I guess you, go ahead. What do you-
We just want to, at this time, emphasize the fact that we had requested 2 lesser includeds, one being involuntary manslaughter, the other being reckless homicide. We did so because we felt that the state had presented ample evidence relative to the issue of reckless, and there could have been certain individuals that found absolutely no evidence of either purposeful conduct or knowledgeable conduct. We feel that by not providing the jury with the options of involuntary manslaughter and reckless homicide, that we had been severely impacted, and the client has been incredibly prejudiced.
Okay. Same response as before?
The same exact response.
Same rule.
Judge, I don't think we renewed the Rule 29s.
I thought you did, but
No, we did. Okay.
And the same thing with Ms. Longino? Did you renew your rule?
yeah, I asked both of them, both defense counsel, whether you renewed it.
Your Honor, for the record, I would like to make the same statement as to negligent homicide.
Okay.
We asked for a lesser included of negligent homicide because of the language of duty of care that was within the instructions, and we think that our client was prejudiced because that was not made an option.
I understand that argument's always an argument, is that? I mean, my ruling. Get the exhibits together.
Yes, Your Honor. I know, but no, thank you.
It's very good. I mean it.
Well, I appreciate that.
Mine, she's the better. Only one time?
Oh, yeah.
That doesn't matter. I will, but I'm telling you that, you know. Well, you know.
Yeah.
Thank you. I appreciate that.
Judge, thank you for all your courtesies.
Where are you gonna be?
I have nothing.
Downtown?
Yeah. And then, I'm gonna be, you know, I'll have my kid here, I'll have my associate, Steve Bradley, and Tommy said he'll be until.
Why don't you guys leave your numbers?
Okay.
Oh,
Yeah, we were.
Oh, yeah, you sure?
There's no like cut off.
Oh, were you busy?
You might want to do that.
You should know, because I used to.
Oh, wait a minute.
Joanna, you wanna hear something?
What?
Oh, no, 2 Marines at one time.
That's the other guy.
Right here, they're right here. Thank you, Michael. I wish you would have sat on this one.
He was supposed to do it,
I know.
but he's leaving, he's not in town.
Sean, the lease? That lease is your name.
Okay.
I don't think I have it.
No, it's in.
Oh, okay.
Lieutenant Reed, will they see me, let them check the code card?
You guys sit around for an hour.
Yeah.
I'll see if they want to leave around 4:35.
All right, I'll be at my office. I'm not going to yours.
See if she is.
You got it.
Yeah. Yeah. Really?
Usually now, they've been here waiting, but they have long days in here.
Thank you again. Bye, you guys.
See you later.
You feel like, I didn't just your observation. Okay, thank you.
Anybody else need to be,
George?
Yeah.
I know.
These are your best shares around, boys?
There's no chance, we don't, there's a, that's why I never. So if I do that,
Well, until the jury will go home.
Yeah.
Did you never know?
They said, well,
I don't know.
we're talking about my.
You're not gonna have a first.
That's all those good checks.
Stick around here.